Good evening, everyone. We warmly welcome you to this legal discussion on intellectual property, a part of phase 3 of Law is Light of the Pro Bono Committee of the Law Students Association of Sri Lanka. In today's increasingly knowledge-based society, ideas have become a key factor in the capital generation and development. Their critical value has given rise to the matters of intellectual property, thereby provoking intriguing discussions regarding the practical legal issues faced in the field of intellectual property. We are expecting to cover those areas in this discussion today. And we are honored to have with us today Mr. Thisya Veeragoda, who is a well-experienced practicing lawyer who has a great deal of experience in the field of intellectual property law. He will be answering the questions collected by us from the general public. As we are streaming live on Facebook, you can ask your question and they will be answered by our speakers at the end of this discussion.
Good evening, sir. Thank you very much for joining us today. Let us start with what is intellectual property. So the main reason we're having these discussions is to educate the general public of the laws, of the various types of laws, to simplify the laws and to explain that there is such a framework in place and to educate them. So could we begin with telling them what intellectual property is?
Right. So basically, if you look at the concept of property, it's things that we can own and possess. This includes things that are tangible, and then there are things that are intangible. So we know a desk, a table, a mobile phone, a property, a house, a car. Those are all tangible property, things that we can see, touch and feel. That's one end of the spectrum. Then on the other end of the spectrum, you get what we call intangible assets. Now, intangible assets are value that is created by assets which can't be seen. But it does create value to the owners of such assets. For example, the name Coca-Cola. It's one of the most worth and one of the most well-known products in the world. If you go and buy a bottle of Coke, you're buying a product, the tangible asset. But the value is not on the bottle itself, but the brand loyalty it had created over the years. So that is an intangible asset, the brand name of Coke. Or if you take some sort of creation, let's say I am interested in photography, I go and take some photos. Those photos are my intellectual creations. So whatever monetization I can make out of that belongs to me. Or let's say somebody else is an author, or somebody is a lyricist, or a music composer. All those people would create something using their intellect, knowledge, skill, and capacity. These, what you create, can be monetized at the end of the day. So those things that can be considered as monetizable, we call them intangible assets. So out of these intangible assets also, a smaller scheme of things are considered as intellectual property, things that we create with our intellect or our mind. So if you look at it, in law, we look at, broadly speaking, 5 different classes of intellectual property. The first being copyright, second being trademark, third being patents, fourth being industrial designs, and then the fifth being what we call confidential information and trade secrets. So that is sort of like a broad breakdown of the concept of intellectual property. So if I write a book, if I take a photograph, if I write a poem, that sort of things fall into the category of what we call copyrights. Then there is trademarks. We all know what trademarks are. Then there are patents. Basically, that is another scheme of monopoly. We can look at it, creation of monopoly. We can discuss it later on, so on and so forth. So that is what we mean by intellectual property.
Thank you, sir, for that detailed explanation. And sir, what is the importance of intellectual property laws?
So basically, if you look at it, since it is a creation of from the mind, the recognition is now, let's say, this mobile phone. I purchased it; it's mine. I can say it. I can see it. I can feel it. I can touch it. I can hold on to it, and I can say it's mine. So any tangible asset, we could all do that. Property, we know that there is a legal regime that says that if it's transferred, you have to register. But that does not necessarily mean that if you are prescribed to it, you will have ownership without any kind of registration. But intellectual property, the laws are what creates that set of rights. It's by recognition that happens. So the first thing that we have to understand is it's a scheme of law that has recognized these particular set of rights and the limitations thereof. So going to your question, the legal regime is what creates these rights and the length and breadth of those rights that we discuss as intellectual property rights.
Thank you, sir. Could you go into detail as to what a trademark, patent, and copyright would mean in layman terms?
Okay. So if you look at copyright, basically in our law, we consider creations of the mind which are either literal creations, artistic creations, or scientific creations. So literature, so a poem, a book, that sort of writing, to a photograph, a painting, a sculpture, all of that would fall into what we call copyrightable creations. If you look at the Intellectual Property Act, Section 6, 5, and 6 of the Act recognizes what are copyrightable works. So if you look at Section 5 of that, which gives the interpretations, it talks of something called works. Work means a literally artistic or scientific work. We refer to in Section 6. So in Section 6, books, pamphlets, articles, computer programs, and other writings, speeches, lectures, addresses, sermons, and other oral works, dramatic, musical, pantomimes, choreographic works, stage productions, musical works, audiovisual works, architecture, drawing, painting, sculpture, engraving, photographic work. So these are the types of work or creations of the mind that the law recognizes as copyrightable works. So if it is a copyrightable work, then the law says that you have certain rights. They are what is there in Section 9 of the Act, basically saying that the author or the creator of the works is the one who holds on to the economic rights thereof. And if you look at it, economic rights also can be sold to various other people. For example, if I own a photograph, I can decide who will own it. As in, I can decide to whom I will sell it. Whether it is only one copy I'm making, or whether it's 5 copies, or whether it's going to be 10 copies. So that is something that I, as the creator of that photograph, will decide. Then I could also decide to license it, to print it and sell it at maybe Odell or something. Or on the other hand, I can decide, no, there's going to be only one copy of this ever published. So that's my prerogative because it's my creation and it's my right to decide. Or I could decide to sell it to someone else to monetize it and make money. I decide, okay, I want 100,000 rupees. I will sell the original to you. Thereafter, you can decide what to do. That's another aspect. Then if you look at something like a song is a combination of several rights in copyright law. The lyricist or the person who creates the lyrics will have a certain set of rights. Then there is also the musical composer who will have a certain set of rights. And then there is the performer who will have his own set of rights. So that's copyright for you. And then the law also discusses how much of the period of time to which you have your copyrights. So if it is a matter that is created by an individual, it's his lifetime plus 70 years upon death. So that's a long time. This has come about after so many years of negotiations around the world. Originally in the 1700s, when this concept came about, 10 years was the time duration. But people realized that 10 years is too short. Now it has become life plus 70 years. So that's copyright law. Do you want me to go into the other aspects individually as well, or would you ask me questions so that I could maybe go into each one of them very briefly?
If you could go into each one of them briefly, that would be better, sir.
Okay. So then there is trademarks. Trademarks and trade names, we know that has business value. Basically, the logo behind you could be registered as a trademark because it has value to whoever the owners of it. So likewise, every business would want to have their own value system because that's how consumers recognize them. So whether the mark is registered or unregistered, in both situations, there are rights that are attached to it, a registered mark as well as an unregistered mark. Both situations, there is exclusive rights and there is no time limitation. So long as you pay on for the registration of the mark to the registrar's office, the trademark will be recognized. Just because the registration has expired does not also mean that there is no longer any rights associated with that. It doesn't happen that way. Unlike copyrights where after the life plus 70-year period, the copyrights will end and the matter falls into public domain. So in trademark law, that doesn't happen. It's a relatively straightforward thing. Unregistered marks will also have protection, which means that someone else who is not authorized cannot use that particular mark. So there's something called a trademark registry maintained with the Register of, which is called the National Intellectual Property Office. And people go search to see whether there is any conflicting or similar marks. If there is no similar mark, then you try to go register your mark. That's how it works. Then there are patents. Patents are concerned with new inventions. There has to be novelty, which means that it has to be something new. It has to have an inventive step, which means that it has to be able to problem solve, and so on and so forth. So patents, once they're registered, they get a 20-year period. And after the expiry of the 20-year period, it falls into public domain. So during that 20-year period, if somebody wants to use it, they would have to pay royalties and purchase that right to use that patented work. So for example, if you take a car, originally someone invented the wheel, the caveman invented the wheel, and somewhere down the line, someone realized we could possibly fix an engine and start running it. Then they realized that, okay, going at that pace is not good enough. If we fix a gear system, the vehicle could travel faster than the wheel turns. And then they realized that when you're going fast, dust comes into your eyes. So first they started wearing goggles. Then they realized that's too cumbersome. They decided to put a windscreen. After they put the windscreen, then they realized that they had to put their arm out and clear up the windscreen because there's rainwater. So they created a wiper, so on and so forth. So that's how inventions work. If you look at some of these new cars, there are hundreds of new technologies, hundreds of new patents that are being developed every day to get these new cars up and running. So technology keeps on developing, so patents also keep on increasing. Then there is also what we call industrial designs. Industrial designs don't require the same strenuous examination like a patent. The requirements are slightly less. The rights that are attached to are also slightly less. Then we also have what we call geographic indicators, which means, for example, Ceylon tea, or the basmati rice, or the champagne. It comes from particular regions. So they are called geographic indicators. Somebody who makes tea in Kenya can't come and say it's Sri Lankan tea. Somebody who makes the long grain rice in Thailand can't come and say it's basmati. Somebody who makes sparkling wine in South Australia or in the Yarra Valley can't come and say this is champagne. That's another aspect. Then we also get what we call the confidential information and trade secrets. The best example I could think of is, once again, Coca-Cola. Nobody knows, except for very few people, nobody knows the recipe. So basically what happens is, it's a trade secret. Or let's say a particular method, a recipe for some fantastic dish somewhere. You don't tell anyone how it's done other than the people who are involved in it. So the people who are involved in that manufacture are bound to protect that secret. So this is not only limited to food and drink recipes. In various industries, financial information to manufacturing information to various other aspects, there are trade secrets. So when a person, for example, an employee receives information concerning some aspect, which has a trade secret, which the third parties do not know, only people who have been authorized know about it, they are under a duty to ensure that that information does not go out. So that is trade secret. So if they breach it, then there are consequences to that. So basically, these are the types of intellectual property that we are generally concerned with. There are various headings under which intellectual property is categorized.
If a person wants to register his own creation or invention, what are the steps he needs to take and what is the procedure like?
You need to be a little bit more, I need a little bit more clarity with your question. If you could tell me. Yeah, go ahead.
Yeah, so if he has an invention and he wants to protect his invention, using the intellectual property law framework, what are the steps he needs to take to protect his invention? Like, whom does he need to go to? What are the procedural steps?
Okay. So inventions, there are two methods of protection. One is the less stringent industrial design scheme. The other is the more strenuous patent scheme. There are two different regimes. The requirements are different. If one looks at the Intellectual Property Act, industrial designs are covered under Chapter 3, Part 3, Chapter 3 of the IP Act. And they only need to establish that there is some form of novelty and that there is some sort of use in that whatever that they're trying to create. So, for example, let's say a pen, there is no innovation involved in it, but the pen might have particular shape or a form which is new. There is nothing, there is no advancement in that pen, but it has a different shape and a different style. So in such situation, you just go and get what you call a industrial design. But as opposed to that, let's say that you create something new, like say the wiper when there was no wiper in existence. Then there is an inventive step. There was a problem in the world to which there was no solution, for which you are now creating a solution. So that is what we call the inventive step. So in such situation, in both situations, you would have to go to the registrar, the National Intellectual Property Office. There are two types of applications, one for industrial designs, one for patents. So you would have to decide which one applies to you, and then you would have to apply. And patents, you have to also remember that you have to say what exactly you're claiming, because you have to give a full disclosure of how things are done. So, for example, I say that this is how this particular product is manufactured, which solves some problem. Then somebody else who looks at that pattern should be able to recreate it. So there has to be a full disclosure. And in doing so, that person would pay me royalties for my disclosure. So that's the whole point. So you have to say, this is my claim, and this is how I do it. And if you don't disclose all of it, you run the risk of your patent getting struck off at some point. Also, you must remember, you need to protect yourself. I'm sorry, not to protect, but you need to, when you're testing novelty, you have to look at a worldwide search. For example, if there is any such other information about such invention in anywhere in the world, the chances are that you won't get a patent issued in your name. Because the idea is that it has to be new world over. It can't be that obvious, and it has to have some sort of industrial applicability. So something that is very technical but does not have any industrial application is also not considered for the issuance of a patent.
Does a person require the assistance of an attorney for these steps, or can he do it on his own?
For the application for a patent, more than an attorney, you would require the services of what you call a patent drafter. So in Sri Lanka, most of the time, there are attorneys at law. But if you look at countries like Singapore, to the US, to the UK, they are very specialized jobs. So in a firm, there might be one lawyer who is also a scientist who does that bioscience drafting. There might be an engineer cum lawyer who might be doing that sort of work. There might be some other tech, maybe some software technology person who has some law background also involved in IT-related patents. So but in Sri Lanka, generally, our scope is not very big. So because of that, generally it's lawyers who draft it. But of course, if the client is well versed with how to draft the claims, then that should be fine.
And so when it comes to, when it comes to music, we see different versions of an old song. So in that instance, like for upcoming musicians, how would they try to have their own version, will they be infringing on somebody's rights while creating a new version of the song?
If you are reproducing a song, then that falls within the restrictions of economic rights in Section 9 of the IP Act. Economic rights, the right of reproduction. So my song, if you sing it, you will need the permission of my lyricist and my producer and my composer, or there might be a situation where the producer has taken all those rights. So it's by agreement. So you would require the approval. But what generally happens is if you're just doing a cover for at a party or something, then people don't really come after you. But let's say that you pick a song, decide to use it in another movie, for example, or you rip somebody else's song, perform it yourself, put it into a CD and sell it. Then because you're making money, chances are that somebody will come after you.
So it revolves around whether you're using somebody else's invention to gain an economic benefit to yourself.
Not just inventions. Inventions relate to patents and industrial designs. But if you look at the concept of IPR, the idea is that no man should be allowed to profit from someone else's labor.
And so when you look at the gem and jewelry industry, where design is a key element, in such instances, does intellectual property have a role to play?
Certainly. So if you look at it, it also again falls within the four corners of the copyright laws. The problem in Sri Lanka is most people don't really care about intellectual property. Most people are ignorant of the law, just like any other aspect of the law, most people are ignorant. I think it's a welcome move that at present they want to introduce law as a subject for schools, because knowing some basic law helps. The issue is that because people are not aware, they are very happy to copy from someone else. Be it a song, be it a poem, be it a design for some jewelry. Whatever it is, you like it, you just pick it up and you do it on your own. No one seems to care. Another aspect of it is we are not a very litigious society, because we all know that it takes forever for a case to finish. So people are very reluctant to come to court and litigate for 5 to 10 years to get something sorted out. But yes, to answer your question, it's something that attracts the copyright law.
And when it comes to designer items like bags, there's something called A-grade bags. Does that infringe the original version, or if you can explain on what an A-grade is about?
Okay, so that's a very interesting topic. If you go to Bangkok and if you walk around the streets, you will see tons of replicas. But if you go to Singapore, you will not see any. That's the legal regime in the two countries. So what happens mostly is that those bags that you call them A-grade or B-grade bags sometimes are actually not knockoffs. Right? They are not replicas or they are not fake bags. They are original bags or bags or whatever the products, which for some reason the actual owner of those products had rejected. Or because it doesn't meet the quality standards, or it is an excess quantity of products. So if it is rejected, then generally the manufacturer is required to destroy them to prevent it going into the market. But what happens in countries like Thailand, sometimes occasionally in Sri Lanka, is that it ends up in the market. So it doesn't sell as an original, it goes as what you call an A-grade product or a B-grade product. So the logo might be a little bit off, not perfectly aligned. The strap might have an additional seam, some small defect. Or it could be an actual product which was overstocked, so it just got rejected. They're two different regimes. So if it is an original product and it has come into a market, not through the recognized channels, then it is something what we call gray market imports. They are not, technically speaking, they are not counterfeit products. They're not fake products. So what happens is, most of the time, the regulators and the owners of the actual trademarks are faced with this question. For example, let's say all these European motor vehicles in Sri Lanka. Most of the agents in Sri Lanka, their prices are much higher than the grey market importers who import from England. So the question is, can they say, no, don't stop the imports of grey market through the grey market? No, you can't, because it's an actual original product. So unless there is some sort of exclusive agreements, territorial agreements with the agents, it's a bit difficult to stop that kind of products coming into the market. But of course, it's very different when it is a counterfeit product. A counterfeit is a product which is not an original. It might be it might look identical, but it is not an original. Counterfeits are illegal. So that is where this A grade, sometimes there is a little bit of blurring of the lines, but if it's a grey market product, then their legal regime is slightly better than that of a counterfeit product. Counterfeit products are liable to get destroyed.
And so now on Instagram, we see various accounts that sell branded items in Sri Lanka. So, and they may be replicas of not the original item. Can they sell the replica at the price of the original item? And if a consumer does buy the replica at the original price, can the consumer file an action? What redress? Can you speak on that aspect?
So if you buy a replica, then that means that you're buying a counterfeit. It's not an original. So then what happens is that you need to be wary of the fact that you have bought a counterfeit. If there is a local agent, you could possibly report saying that there is a counterfeit product in the market. Please look into it, because when there are counterfeits, let's say the product is 10,000 rupees, the original, I go and buy a counterfeit for 7,500, thinking that that's an original with a discount, then that affects the brand. So because of that, brands are very concerned, and they generally take legal action to prevent counterfeits coming or replicas coming into the market. But the reason why you see that sort of products in Sri Lanka is that the Sri Lankan market is relatively small. So some of these issues might go unnoticed. So that's one of the reasons why people might not know of this sort of activity.
So you spoke of trade secrets and recipes. So does this apply to perfumery as well? Because they have a strict recipe to have their own brand. So how does it apply to the perfumery industry?
Absolutely. So perfumeries and things like that, that's exactly how it works. There'll be like three or four people who would know exactly how that product is manufactured. It's same with, for example, what you call these master blenders of tea, for example. They are the ones who know how the exact taste going for every batch, or for alcohol, for example, the whiskies, Scotch blended whiskies, for example. So if you look at it, they are all trade secrets. So let's say that I am working in a what you call for a tea trader, where mixing happens, and I've learned a particular recipe. If I go and join a competitor, or if I go and start my own business, there is a part of knowledge which comes naturally to me by being an employee. Then there is a part of the knowledge that comes, which is exclusive, and it had come to me because of some confidence placed in me. So they're two different things. For example, I work for a senior as a junior lawyer. I will learn certain things about how to be a lawyer. That is what I learn in the ordinary course. Then there will be certain things that I learn about particular clients. For example, this client has this particular issue and I have advised him on that. This client has this particular issue, we can charge X amount of money on that. That is information that I get that has nothing to do with my work per se or my capacity per se, but it is something that I gain through confidence or through confidential information. So we need to draw a distinction between these two. So now you spoke about blender of perfumes. So how to blend is something that person will learn on the job. What perfumes to mix to get a particular smell, if I was taught that is confidential. So when I leave that employment and I go somewhere else, what I learn about blending, I can use. But that particular recipe that I learned, I can't use. So it's a very thin line. And it's so thin that it sometimes overlaps. It's very difficult for courts. And if we look at this litigation, sometimes what happens is that an employee leaves, goes join someone else, or he goes and joins, sets up his own business. The former employer fears that, okay, my part of my market share will go away. So I have to be very careful. The moment the new guy goes and approaches a former client, for example, there will be litigation. But it's very difficult to succeed in confidential information litigation because it's very difficult for you to prove that what was taken out was in fact used in the new business. So that's a problem that we have. But to answer to your question again, it's basically there are two elements. One is the experience and the exposure you gain, and the other is the more secretive, selective information that you gain. That information must continue to be protected, even if you leave that employment.
So does infringing an intellectual property law amount to criminal liability? Sometimes,
yes. If you look at the IP Act, there are certain offences. Violation of a trademark is one of the most common offences. If you look at section 170, if you look at section 170 onwards, I believe. I'm sorry, 177. Any person who willfully infringes any of the rights protected under Part 2, that is copyrights, shall be guilty of an offence and shall be on liable conviction after trial before the magistrate to fine not exceeding rupees 500,000 or an imprisonment of term not exceeding 6 months or both such fine and imprisonment. In the case of a second or subsequent conviction, such fine or term imprisonment or both such may be doubled. Right? Then infringement of industrial designs. Any person who willfully infringes the rights of any registered owner, assignee, licensee of the industrial design shall be guilty of an offence, 500,000 or imprisonment for a term not exceeding 6 months or both such fine and such imprisonment. Second or subsequent conviction, double. Then infringement of patents, that is in section 181. Again, 500,000 or imprisonment of 6 months, and doubled for second or subsequent offences. Infringement of marks, section 184, any person who willfully infringes the rights of a mark, again 500,000 rupees or 6 months. And subsequent offences, punishment is doubled. So there is criminal liability that is also attached.
See, the general public who are watching this, they would like to know what characterizes an intellectual property, like what kind of property is governed by intellectual property law. How would they figure it out? Or do they need to speak to an attorney to find out if they need to protect whatever they are having? So, for example, a business, they start a business.
Sorry, I didn't follow you.
So what are the characteristics of an intellectual property? Anything that comes under intellectual property?
Okay, so the 5 main items: copyright material, that's you create something, a song, write a book, write a short note, an article, take a photograph, create a sculpture, all of that comes under copyright. Then trademarks, that's creating some sort of brand. Patents, it's a bit more complicated, like I told you, patents and industrial designs. Then the trade secrets, you create a recipe for your grandma's favorite soup. That might be something you can convert into money. So you decide to keep it as a trade secret and not tell anyone and what the secret ingredients are. So that's intellectual property. You might sometimes want, because a lot of times we get clients coming in and saying, I want to patent something. Because that's what people think when they say intellectual property, the only thing that is covered is patenting. Patenting is there, as I said, only in relation to certain types of intellectual property. It does not now. Even today, I got a phone call from someone saying, look, I want to develop an app. I want to patent it. But when you listen to that person, you realize that, no, it's not patentable, but it's probably protectable under copyright. So then you advise the client. And generally, it's always better to get advice from attorneys on these particular aspects of intellectual property, because most people don't understand it and most people don't know it, the layman. And if you look at it, sometimes most lawyers also, I wouldn't say all lawyers, but most lawyers might not be familiar with the intrinsic details of intellectual property law as set out in the IP Act. So it's always better to have a chat with a lawyer and get an opinion before you go start some sort of financial venture which involves intellectual property rights.
Now we see a lot of photographs being copyrighted. So if somebody uses a photograph that has been copyrighted without attributing rights to the owner, what kind of action can be taken against that particular individual? And also, for example, if a self-portrait is used without that person's permission, if a self-portrait is used without the person's permission, can that individual take any legal action under intellectual property law?
Okay, so there are 2 issues. One is photographs. So basically, let's say I take a photograph of something and I decide to publish it on Facebook. There is no such thing as copywriting something. Copyright law says by virtue of creation, irrespective of artistic merit, it is protected, right? I'm going to show you guys an example, but while doing that, I will explain further. So let's say a photograph, you take it. The moment you take it, it's protected, right? and then it's life plus 70 years. Just hang on for a second. I will. So basically what happens is most people in Sri Lanka have no idea that once you take a photo, that's when the copyrights are created. People seem to think that if you upload something to the internet, then someone else can just copy it and paste it somewhere else and make it their own thing, right? So I'm going to share a screen no, I can't share it. Can I share the link here so that somebody else can share the screen?
Don't you have the permission, sir?
Nope, I don't. Host has disabled screen share. Just share this in the link.
You have been made the co-host, sir, so you can share it.
Okay. Okay, so can you see this photo?
Yes, sir.
Yeah. So this is a photo that I took about 15 years ago. I had it at an exhibition, and then I put it up on Flickr on my Flickr page. Before Facebook came and took over the world, Flickr was the place where photographers shared their photos, right? So if you look at it at the bottom, my name says copyright available, all rights reserved 2007, right? And then one fine day, how do I get out of this now? How do I?
Stop screen sharing.
I can't see it.
I think it's at the bottom, sir.
No. Okay, got it. Sorry about that. Not so tech savvy. So basically, one day I find that photo was used by a newspaper, Divine. I was quite offended. Young lawyer, just taken notes, just finished my master's in IP and come back. Then I find this photo on the newspaper. One of my friends called and said, Machan, your photo is there. Then I called them up and I asked, I called up the editor and I said, I'm so-and-so. You've used one of my photos. He said, එහෙමද? ඔක ඉන්ටර්නෙට් එකේ තිබලා අපි ගන්න නැති. Very casually. So then I said, well, internet එකේ තියෙන ඔක්කොම ඒවා ඔයගොල්ලන්ට ගන්න බෑ. Then he said, නෑ අපි මාධ්‍යනේ අපිට පුළුවන් ඕන දෙයක් කරන්න. So it's like, well, not exactly. You can't do that. You would still need my permission. Then he said, why did you put it on the internet? So I said very clearly, copyrights reserved. Even if you don't say copyrights reserved, copyrights are always reserved. That's all. I said, the little law that I know tells me that you can't do that. Those were my exact words. And then he said, So I went to my boss at the time, Dr. Harsha Kabral, and I said, sir, somebody had stolen my photo and put it on a newspaper. So he was like, let's go ahead, let's file action. So we did file action. The newspaper ended up paying 200,000 rupees as damages, as a settlement, which was paid to a children's home and an elders home, 100,000 bucks each. And then they published an apology and removed the photo. Right? So the bottom line is nobody can just take a photo just because it's on the internet. Right now with Facebook, right click, save, it's very convenient to hijack other people's photos and make them look like their own. So that's why on Instagram, on Facebook, there are so much of copyright protection mechanisms, copyright complaining systems. So all of those have come about because of that reason. So that's one aspect. Then the second question you asked, Lynette, was whether portraits, self-portraits could be used by someone else. Two sides to it. If the photo was taken on my behalf by a photographer, I would be the owner of the copyrights to it because it's what we call a commissioned work. Then the second side to it is there's an element of privacy attached to it. I might decide to put it up on Facebook as my profile photo, but that does not mean that someone else can take it and use it to display or use it for an advertisement. Let's say you're on a street. Now, I sometimes do a lot of street photography. So on the road, I might take photos of maybe a celebrity, but I might be able to use it to say that I took a photo of the celebrity, but I might not be able to sell it to an advertising company to use it for some advertising because I would need that celebrity's permission to use that image for that purpose. They're called personality rights or personal rights. That's part of privacy law. So let's say while we are talking here, you take a screenshot of my face and then use it in some other, I'm just giving you a real life example. There's this client of ours whose profile photo was downloaded by a teledrama director and used that photo to portray a dead person's character in some teledrama. And so imagine the shock to the real life person. Okay. So then we looked at various aspects. There was a copyright aspect as well. Then we thought, okay, fine. We're going to go along the privacy law aspects. I might decide to put my profile photo up on Facebook or wherever. But that does not mean that somebody else can take it, go and use it elsewhere. Right? So at the end of the day, that is another aspect of the law. That's privacy law. And people are entitled to protect their privacy in terms of Roman Dutch law, not in terms of an act of parliament, to protect their image, their portrait being misused.
When you talk of artworks, now we see different people redrawing ancient art, for example, the portrait of Mona Lisa. So if a young artist decides to repaint Mona Lisa, and can he say that it's his own work and sell it, or maybe display it at an art exhibition, or should he, what should he do?
So Mona Lisa, Da Vinci's creation. Da Vinci had been dead for so many years. The copyright protection lifespan has expired, so it becomes part of the public domain. So if you draw it, you don't have a problem. That copy or that particular version, I mean, if you go into a particular restaurant at one golf face, you would see Mona Lisa holding a beer, Mona Lisa holding a pizza, and something else. There is no problem in that. There's no problem in that. But let's say you go and some new thing. If you take that new creation, a new painting, a new photo, like for example, my photograph, if you take that, I'm violating my rights. Because I'm still alive, the copyrights are still active. So when that Sandakada Pahana image issue came about, the editor of that newspaper said, Sandakada Pahana copyright ne. I said, Mama, Sandakada Pahana mage kiyanne. I'm not asking for the Sandakada Pahana. I am asking for that particular photograph of the Sandakada Pahana which I took. And no one else can use it without my permission. Right? So that's the difference.
Okay, sir. We've come to the end of the discussion, but now we move on to the live Q&A session. So prior to this event, we have circulated a Google form where the general public can send us questions. And we've received a couple of questions. And one of the questions is, and I'll quote, a person has written a book using another person's personal life experience. And that individual experience that individual shared with him in confidentiality. Can any action be taken for such publication?
Yes. So there are two elements again. In fact, just before we started this discussion, we had to have a consultation on something along the same lines. So it's sort of like a memoir that somebody is writing where someone else's life is being disparaged. Correct? That's the question. I the way I understood it.
Yes, sir.
So
yes,
if
sir.
it is something of that sort, it can't necessarily be protected in terms of the intellectual property. Right? Because it is not necessarily a copyright issue.
Did Sir get disconnected?
Yeah, I got disconnected. I'm sorry. I'm back.
Okay.
Okay. So if you really look at it, it's another matter for privacy laws. So let's say that you write a book where you're disparaging me in it, then I might not be able to stop you in terms of the intellectual property law, but I might be able to stop you in terms of the privacy laws, because you might be defaming me in your book. So if it's defamatory, then I can file a defamation action. But even if it is not defamatory, but your book results with me having to lower my dignity, my self-worth, then I might be able to sue you to protect my dignitas. These are all Roman Dutch
Even
law.
if your name is not mentioned?
If your name is not mentioned, but even then where you can be identified, specifically identified. So otherwise what would happen is defamation would happen without the name being mentioned, but then everybody would know that so-and-so is being defamed. So it's the same thing.
Right.
So that would be covered under the civil laws or the Roman Dutch law.
And on the topic of pictures and privacy, when it comes to pornographic pictures, is that under intellectual property or does that come under criminal law? Or is there an overlap?
In the sense, let's say that the image, the
For
video.
example,
yeah, go ahead.
Between a couple who is in a romantic relationship, and there is an exchange of pictures, and then we call it revenge porn. Is it? Yeah. So in such an instance.
So yes, one aspect is the copyright laws coming into play, and wrongful distribution would be covered under that as well. But there are more simpler ways of dealing with the issue under criminal law.
Okay.
So I would say if there is such an issue, don't look at the intellectual property law aspects of it. Just go through the criminal law system because it's much more quicker to resolve. And because of penal sanctions, people might be more inclined to resolve than in civil actions.
Okay. Thank you very much, sir. We have come to the end of the session. Farah will deliver the vote of thanks.
Thank you very much.
Farah.
I would like to take this opportunity to thank our respectable speaker, Mr. Pishya Veragoda, for sparing his valuable time of his busy schedule to enlighten and educate us by sharing his immense knowledge on the subject of intellectual property law. It was a very fruitful session and we have definitely gained a lot, sir. I would also like to give my thanks to Nirmal Pereira, member of the media committee, for his endless support in making this a success. Also, I'd like to thank our participants for being here with us throughout this session. Thank you and have a nice day.
Thank you very much.